Hello, everybody. Good morning. It's Dave Neal, stand-up comic and host of Bachelor Nation News. We have an update in the Clayton Echard paternity scandal rocking the world. That's right, a response by Clayton's side to a motion for judgment on the pleadings and renewed motion to dismiss. Well, now we hear from Clayton's attorneys, and they lay the hammer down, as you can see from the thumbnail. They call out Jane Doe's strategy, efforts to intimidate, which, again, is nothing new. We've seen this for years now, dating back to 2021. Limited Instagram stories that were targeting Greg Gillespie, that were just absolutely ridiculous. All the receipts from these we've shared in different capacities. Babies' names for 2021. Surprised that Grace and Gabby didn't make the list. A woman never forgets how a man treated her during the time she needed his support the most. You have nothing to fear if you have nothing to hide. Guys, these were things that only Greg was getting. Insightful stuff. Happy birthday to a really special guy. Cheers to the best year ahead. The expectant father should be required reading when you're a father-to-be, and a baby will soon have your last name. Guys, absolutely ridiculous stuff. So anyway, efforts to intimidate, nothing new here, but we're going to be looking at what was said in this motion. Very fascinating. Let's dive right into it. The response objection to petitioner's motion for judgment on the pleadings and renewed motion to dismiss. Defendant Clayton, by and through counsel undersigned, hereby files his response. General availability of attorney's fees and sanctions. Before addressing the balance of the motion on its face, the court must be aware that Jane's entire argument presents a false choice fallacy in an attempt to artificially limit both the scope of the pleadings and the court's authority. Yeah, essentially, Jane Doe's lawyer says, look, this whole trial is simple. It's down to one thing. Did she believe she was pregnant or not? And again, the argument would be, first off, no, that, Clayton's argument is the same as Greg's and Mike's and Matt's, which is that it was all part of a larger con to attract men into some sort of contract to date her. What is the motive there? Well, in some cases, like Greg Gillespie's, the motive is possible punitive damages or just making these guys pay, as seen by Instagram stories like this. Like, you are just going to have to pay for the stuff that happened here, Like, that's nothing new, folks, nothing new. But as we continue here, we see that it's not as simple as a false choice fallacy. Rule 26 is not and has never been the exclusive source of the court's authority to award attorney's fees, and it does not govern Clayton's substantive claims for relief raised in the pleading. Therefore, the question before the court is not whether it can award sanctions under Rule 26 or no sanctions at all, as Jane falsely frames her argument. Rather, the question is whether Clayton is entitled to adjudication on his claims for fees and sanctions under any authority invoked in the pleadings or inherent to the court by virtue of its statutorily mandated rule duties. The answer to that question is clearly yes. Jane knows, or at least should know, based on the plethora of written communication and filings about this issue, that her proffered Rule 26 or dismissed to action dichotomy is both frivolous and misleading. Title 25 contains at least 3 statutes that expressly instruct the court to award attorney's fees and sanctions a party in response to unreasonable conduct in the litigation. And again, so clearly Clayton's side thinks that they should be awarded attorney's fees, which probably would come out to over $150,000 on his end, and whatever, she would have to pay that bill, because they believe that it's been unreasonable conduct, which, again, if there's any shred of truth to that, I imagine the judge is going to come down heavy on Jane Doe, just from everything I've gleaned here. I don't imagine this judge. I mean, the fact that the judge has opened up for more, medical information, extended how long the court hearing would be. All these things lend me, a novice bystander here, to believe that she ain't playing around right now. Clayton has already articulated in several filings, including in his motion for leave to amended response, objection to petitioner's motion to dismiss, and motion to withdraw the motion for sanctions pursuant to Rule 26, the statutory basis for his claims for relief. Moreover, those provisions apply to all proceedings brought under the relevant chapters of Title 25, of which this paternity action is one example. Every litigant has notice of the court's duty and authority to sanction unreasonable conduct in family court actions. Rule 26 is a procedural mechanism for sanctioning a party for the contents of their filings at any time, even before final resolution and notwithstanding the prevailing party in the action, and does not replace, supersede, or otherwise affect the statutory claims for relief whatsoever. Arizona courts have repeatedly recognized that when a substantive statute conflicts with a procedural rule, the statute prevails. And then he cites the case there. Rule 26 governs relief pursuant to Rule 26 and nothing more. Even if Jane's argument interpreting Rule 26 were correct, a conclusion Clayton certainly opposes, the net result on the posture of the case would be absolutely no change at all from the existing trial scheduled on the merits of the pleading. Accordingly, her prayer for relief, improperly styled as a motion for judgment on the pleadings and renewed motion to dismiss, was already moot before it was even filed because Rule 26 is not at issue. The motion has no bearing on the resolution of this case. As detailed in prior filings, by withdrawing his Rule 26 motion, Clayton hoped to avoid Jane's noxious agenda of papering the court with dozens of pages of meaningless debate on this topic. But Jane appears determined to have this purely theoretical argument regardless. So as we showed before, Clayton's attorney, Greg Woodnick, had said that he regrets dropping that one specific motion because he did it anticipating it would, limit the case down to something very specific. But then he noticed and realized that Jane was going to try to exploit whatever she could, really, which doesn't argue the actual points here. Response to motion for judgment on the pleadings. As and for his response objection, Clayton states as follows. Clayton provided written notice as required by Rule 26. Again, I know some of this is boring, but we're going to get through it and we're going to get to the goods. As addressed in depth in his motion to withdraw, Clayton's motion for leave to amend provided notice of his intent to seek sanctions against Jane and cited Rule 26. The court granted leave to amend and accepted the amended response, also citing Rule 26, and indicating an intent to seek sanctions against Jane on January 25th, 2024. On December 28th, 2023, more than 10 days after being notified of Clayton's intent to seek Rule 26 sanctions via the motion for leave to amend, Jane moved to dismiss her petition because she was cryptically no longer pregnant. Clayton timely objected. On January 25th, 2024, the court deliberately indicated it was not dismissing the action because Clayton is entitled to resolution of his claims for a finding of non-paternity, attorney's fees, and sanctions. So yeah, it was almost like Jane thought that all she had to do was dismiss this and it would go away. And this is where, it's become different than past cases where Clayton has had the wherewithal to say, no, enough is enough. We need to establish that I had never been the father and X, Y, and Z. And again, just know that this will all be used against him in some sort of TEDx talk if he doesn't do the right thing and take this thing as far as he can to court. The court upheld an award of sanctions despite the part. Okay, so they cite some case law there. But let's keep on going. Even if the court finds Clayton did not provide proper notice, Rule 26 is just one avenue for sanctions. If the court treats Clayton's response to petition for paternity as true and correct, as Jane now requests, there are independent statutory claims for attorney's fees and sanctions that have nothing to do with Rule 26 sanctions and have no safe harbor provisions. Statutes are superior when it comes to substantive claims, and rules are superior when it comes to procedural matters. And the statutes provide substantive claims for relief separate and apart from Rule 26. Rule 26 is a carryover from the rules of civil procedure as a remedial measure for frivolous claims and filings during the pendency of the proceedings, not a mechanism for defeating substantive statutory claims for relief, as Jane suggests. As a broader legal point, and by the way, Clayton's attorney teaches law. So he's got his, this is sort of his, this is his home field advantage here. So whereas Jane's attorney thought, if we just argue Rule 26, we can have this thing thrown out. Clayton's side says, not in family court, hombre, not in family court. As a broader legal point, case law interpreting the limitations of the court's authority to sanction improper filings in a civil matter is not directly analogous to Rule 26. insofar as Rule 26 exists in a completely different environment of statutory claims under Title 25, allowing different reliefs such as sanctions and attorney's fees by statute. Interpreting Rule 26 as an analog to Rule 11, Arizona Rules of Civil Procedure, makes sense in the context of the language of the rule itself. But once the analysis moves beyond that and onto the question of whether there are alternative grounds for the same relief, Title 25 is tremendously broader and more remedial than the legal authorities relevant to the various cases interpreting Rule 11. I know, folks. I know. Not that sexy yet. Regarding the safe harbor notice provision, that portion of Rule 26 permits a party to correct or withdraw a filing within the notice period, but it is not an absolute right to withdraw the entire action. As previously addressed in his motion to withdraw, if Jane's theory that she was denied an absolute right to withdraw her entire action were true, no party would ever move for Rule 26 sanctions. Under Jane's view, that would hand the other side a monopoly-style get-out-of-jail-free card to avoid consequences, regardless of the extent of the frivolous, inflammatory, and impermissible claims in their filings, or the outrageousness of their conduct after filing, which is an independent basis for statutory relief entirely. Jane's motion for judgment on the pleadings seeks that the legally extraordinary and practically inexplicable relief of dismissing the entire action that she improperly brought. Even assuming in arguento that Jane was entitled to a 10-day miracle cure period to undo her past bad acts, she has already been given those opportunities and did not accept them. Yes, she moved to dismiss her petition eventually, but it was well after 10 days from Clayton's motion for leave to amend. It was denied because Clayton had material statutory claims entitled to resolution on the merits. There is simply no reason to believe there was ever a time that Jane would have voluntarily withdrawn her claims, even if she was given that opportunity with no strings attached. Instead, her antics continued, including alleging that a prior victim fabricated her medical records, which she now appears to be claiming she does not remember creating the allegedly fabricated medical records. Here, Jane's conduct in this action and the other two protective order proceedings clearly fall within all of these categories, as Jane allegedly frivolously brought the underlying action alleging she was pregnant after non-intercourse with Clayton's twins, and continued to perpetuate alleged fraud upon the court by submitting knowingly fabricated medical records. Jane has behaved inflammatorily by continuing to present herself as 24 weeks pregnant with boy and girl twins and repeatedly testifying to actively being seen by physicians who have since disclaimed ever seeing Jane as a patient, and by engaging in toxic diatribe on Twitter and blog posts, including attempting to intimidate witnesses. Nearly all of Jane's filings have contained legally impermissible claims. For a limited example, Jane's motion to communicate in this motion for judgment on the pleadings. Lastly, her conduct in this litigation has been extremely outrageous, to wit, admittedly fabricating medical records, baselessly accusing others of fabricating the records she herself tampered with, and allegedly committing perjury in multiple filings and in statements before this court. Notably, Jane bizarrely appears to continue to allege the sonogram that she admitted to doctoring and that did not originate in either location she alleged is legitimate despite mountains of evidence to the contrary. Moreover, and by the way, we should really try to find the origins of that ultrasound. Moreover, Clayton even offered several times for Jane to walk away from this litigation if she apologized and admitted she was never pregnant with him by twins. Jane rejected every effort to resolve this matter and even engaged in overt efforts to intimidate witnesses into not participating in the process by threatening to have them arrested, Mike Maricini. As referenced in Exhibit 2, she, through counsel, mentioned having Mike Maricini arrested for attending the hearing. His subpoena is attached. Then she conveniently failed to mention in her recent reply in support of Jane's motion in Lemonade that she has been in contact with Mr. Maricini and his attorney, and he has clearly indicated his desire to have his voice heard at trial. Exhibit 3, moreover, on April 22nd, 2024, via counsel, stated, I am happy to discuss settlement, but I also need to be honest. When Jane prevails in this case, she is going to sue Clayton and many other people for defamation and other torts. We can certainly avoid that if you want, but it's going to involve someone writing a very large check to Jane. If you offered $1 million right now, I'd advise her to reject that offer. Exhibit 4. It is tremendously convenient for Jane to announce here at the proverbial 11th hour that she would have withdrawn the petition months ago if given the chance. The well-documented history of this case and the companion order of protection cases where her conduct under oath was even more outrageous necessitates a different conclusion. Even if Jane had attempted to withdraw from the action entirely, that was only subject to the court's approval and Clayton's right to object consistent with Rule 46. Rule 46 must be read harmoniously with Rule 26 in the Title 25 statutes. A harmonious reading of Rule 46 and 26 tells us that a pleading can be withdrawn voluntarily before a responsive pleading is filed, but after a responsive pleading is filed, it can only be withdrawn with the court's permission after consideration of the opposing party's right to have their responsive claim and counterclaims adjudicated. Jane has already tried this and was denied by this court. The Rule 26 notice would allow a party to correct a pleading or withdraw a claim, but not to dismiss the action without the court's permission after an answer is filed. The court should not grant permission if, as here, the respondent asserted substantive claims entitled to adjudication in their responsive pleading. This is the only way to read Rule 26, Rule 46, and Title 25 together that does not subordinate one procedural rule to another or nullify statutory claims that cannot be abridged by procedural rules. Notwithstanding all of this, a motion for judgment on the pleadings makes absolutely no sense in this case's context. Judgment on the pleadings would require the court to find Clayton's allegations in the response that Jane was never pregnant with his twins as true, and therefore find her subsequent representations to 3 different judges under oath were maliciously fraudulent. That kind of conduct is exactly why that rule exists. Her position here would turn Rule 26 into an escape hatch for any litigant wishing to avoid the consequences of their own actions. If Jane now concedes that her claims were always fraudulent, as Clayton believes, or just, according to her counsel, misstatements, then the court can proceed just in determining the appropriate sanctions and attorney's fees to award. It still must award them pursuant to statute. Whether Clayton filed for sanctions under Rule 26 or not, trial would still occur. Even assuming this court agrees with Jane's highly contested interpretation of Rule 26, the parties would still be heading to trial. Clayton is entitled to a hearing on his counterclaim for a finding of non-paternity and attorney's fees and costs. As Jane has repeatedly indicated in her filings, emails, blog posts, and tweets, she has no interest in conceding what Clayton has alleged since the beginning, that she was never pregnant by Clayton with twins after their non-intercourse. Had Clayton never mentioned Rule 26, Jane would have no safe harbor to withdraw her claims, and the court would proceed to trial under any of the half dozen or more other sources of authority to adjudicate the claims before it and sanctions misconduct. Interpreting Rule 26 and the safe harbor period as a necessary precedent condition for the court to sanction a party under any other source of authority at law or in equity would be the most absurd result imaginable. The court cannot read a rule as requiring an absurd result unless that is the only plausible reading, and that is clearly not the situation presented here. Oral arguments is an unnecessary and expensive distraction on the eve of trial. Efforts to delay and avoid this trial are over the top. This is a bench trial that is set to take place in less than a month. If Jane desires to use this motion of her limited time at trial to argue about procedural rules that have no bearing on the substantive issues of the case, that is her prerogative and should count against her limited time. Clayton should not be forced to participate in such futility because his analysis of the Rule 26 issue has been thoroughly explained on the record twice. This is the Conor McGregor litigation that was promised by Jane's counsel and is only exemplified by the personal tweets, blogs, and what this court may see as efforts to intimidate for no reason other than to dissuade just resolution of claims. It needs to stop. Wow. So as mentioned, the Conor McGregor of litigation. He says, look, this is what he said he was going to do. This is what he's doing. I mean, like, do you appreciate this, Judge? I mean, that's what it comes down to. Does the judge appreciate this? Clayton is entitled to his reasonable attorney's fees and costs. Clayton exhaustively outlined in his motion to withdraw most, if not all, of the factual and legal bases outlined in this response. Jane did not even reply to Clayton's motion. Instead, she agreed with it and filed a notice of non-objection. The withdrawal was filed to avoid more of the toxic litigation, threats of appeals, and personal sanctions and bullying efforts. It did not work. Still, Jane seeks yet another impossible form of relief in a motion designed to increase expenses and avoid trial. She requests oral arguments. on this matter, despite already knowing constructively, if not actually, that her argument is not well grounded in law. Clayton requests that he be permitted to submit a China doll affidavit that includes all of the prior unwarranted and legal inappropriate filings he has had to defend himself against in this litigation. So there it is. They submit it, and Clayton verifies it, and we go to the exhibits. Exhibit is motion to withdraw motion for sanctions pursuant to Rule 26. So we've already seen this. We can fast forward through that exhibit here. Again, I know it sounds pretty boring. It's real like legal chess work here, this Rule 26 idea. But what what Clayton's attorney, Greg Woodnick, is arguing here is that there are plenty of avenues to get fees. So even if they're going to argue on whether or not there was the appropriate time for this rule to be exercised and for Jane to withdraw, doesn't make a difference because, it's been clear that this has all been going on. Clayton would rather avoid the $35,000 sideshow Jane intends to use to distract from and avoid the merits of the claims against her. Because the Rule 26 motion is not the substantive pleading basis for claims against Jane, there is no reason to participate in the pointless litigation of this issue, notwithstanding Clayton's disagreement with Jane's position. So I'm not going to share this one because this is from early April and we've already shared that. So I'm not going to share these exhibits. But we'll see what else is in these exhibits here. So here's a new exhibit, and I don't know what this is from right here, but it's I believe from her attorney. If Mr. Maricini does not want to comply with the procedural rules, that's 100% okay. I am more than happy if he wants to stay home, assuming he hasn't been lawfully summoned. But if he comes within 100 yards of Jane without being compelled to appear by valid subpoena, then he will risk arrest and prosecution for violating the restraining order. So this is kind of also another false thing here. I think it was Jane's attorney knew that Mike Maricini wasn't going to get arrested if he shows up lawfully, because that was the plan all along, but says, well, if he doesn't show up lawfully, it's like, well, if you steal something, you're going to get arrested. Okay, fine. But the way it's worded here, it's that Jane will have you arrested if you show up unlawfully. And that in and of itself, to someone who's there to witness, to be a witness against Jane, you could see that as witness intimidation. I don't think they would take a rocket scientist to say that. Based on this rule, I assume Mr. Woodnick has not instructed you or Mr. Maricini to refrain from speaking to me. Also, just to be clear, I am not under any circumstance suggesting Mr. Maricini should not participate in the trial if he has relevant information. All I am saying is that if he wants to testify, he needs to do so in a manner that complies with the rules and the law. Finally, please note that it is a felony under Arizona law for any person to unlawfully withhold testimony to evade legal process to appear. So he says, look, I'm not threatening you. I'm not telling you not to appear, but then he says you might get arrested. So clearly this, is at the very least, just ugly. Order to renew DV restraining order here. And then here's another order, which was the renewed restraining order for Michael Maricini. And she has continued to renew her restraining order. She's got it for a long time. So here is the subpoena, it appears, to Michael Maricini for attendance of witness at hearing or trial. You are ordered to appear in the Superior Court of Arizona in Maricopa County at the place, date, and time specified below to testify at a trial in the above-named case before judicial officer, the Honorable Julie Mata. And there it is. The courtroom 102, time 8:45 a.m. We will be outside the courthouse, probably at about 7:45 a.m., live reporting from the Northeast Regional Center. Anybody is allowed to attend. If people want to go and show their support for Clayton, Mike, Greg, Matt, Woodnick, Neal, whoever you want to come show support for, you can do that. You can also just be there to watch the judicial system play out. But that will be at 8:40 a.m. Arizona time. So they share the duties in response to the subpoena, the attendance of Mike Maricini there. Very standard stuff here for what is involved in a subpoena. But it just goes to show that they have done the effort, the work to get a subpoena for Mike. Why tell someone, hey, you will get arrested, if you don't have the right subpoena or paperwork to be there. Like, why even tell them that? It's the same reason her attorney emailed me telling me how badly I'm going to be sued here, because the efforts are to, A, for me, get me to stop talking about this, or be more fair towards Jane Doe, as if it's like, why does everyone have a stick up their ass about what I think? You know what I mean? So anyway, the subpoena continues. We don't need to share all of this. Signed, sealed, and delivered May 7th. 2024. So a whole week ago. So this subpoena was there for Mike, so he's lawfully allowed to attend. And then in this matter, affidavit of service for subpoena in a family case. I received this subpoena addressed to Mike Maricini. So there it is. They confirmed they received it right there. And we continue. Exhibit 3. From Mike Maricini. And again, we already shared this, so maybe we'll be quick. Greg Woodnick reached out to me. This is from Mike Maricini to the law offices of David Gingras. Greg Woodnick reached out to me and gave me your contact number because you have expressed a desire to speak to me. I want you to know that I was about to call you and tell you about my harrowing experience with Jane Doe and all the lies she told, including, but not limiting to, lying about being pregnant with twins, telling me she had cancer, threatening suicide, and emotionally terrorizing me to coerce me into a relationship with her. But before I could pick up the phone, I saw that you tweeted out a photograph of me and Jane and audio from a radio show we did together from that traumatic time in my life. I cannot express to you how inappropriate and offensive that action was. You have accused me of fabricating evidence and lying, which led me to take my laptop directly to an expert for analysis. I had moved on with my life and had no interest in opening up old wounds that have so injured me, but you made it impossible for me to sit quietly. You posted my deposition online to accuse me of lying, and you humiliated me purposefully. I deeply resent the allegations, which is why I decided to turn over my laptop as evidence in the Clayton Eckert case against Jane. We both know that she sent those doctored medical records to me, and now you have the proof. I could not, in good conscience, remain quiet and watch Jane use the same playbook against another innocent man. I've decided that I will not speak with you on the phone. I will speak in a court of law on June 10th, under oath, and I will tell the truth about the horrors that Jane visited on my life. You may ask me any question you want, and I will answer with the whole truth. You do not understand or willfully refuse to accept how traumatizing my interaction with Jane Doe has been. She has destroyed my reputation and ruined background checks by taking out a fraudulent order of protection against me based on lies that have affected me personally and professionally. She accused me of horrific acts of domestic issues that never happened. She fabricated medical evidence and held threats of suicide over my head and keep me locked in a relationship that was toxic and deeply disturbing. But perhaps the worst thing you have done is to suggest that I should talk to Jane, the woman who attempted to and in many ways did destroy me. This is the same woman who continues to renew the false order of protection against me and pretends to be terrified I'll be in the same courtroom as she. Why would someone so afraid of me want to speak to me and violate that order she insists she needs? This just a day after you threatened to have me arrested if I showed up at the courthouse to be a witness. The fact you would suggest such an inappropriate call between me and my abuser proves to me you have no idea how inappropriate it would be to speak to the women who fabricated wild tales about me and turned them into a TEDx talk in an entry into Chicken Soup for the Soul that will live on forever. This letter, which has been painful for me to write, has addressed everything you wanted to speak to me about by phone. All the best, Michael Maricini. These guys aren't playing around. These guys aren't playing a game. And her attorney's threats at $1 million lawsuits now and defamation. Everybody who spoke out against her is going to be sued here. Mike Maricini, Clayton Eckert, even maybe Matt, Greg Gillespie, now myself, probably Greg Woodnick, all say the same thing. Bring it the F on, because the truth rises to the surface. And if anything, levels of the truth have been hidden from this court case. A court case that only has 2 hours to be adjudicated. A court case that in some instances doesn't want to bring back past actions. Well, bring it on in a suit, because then it all comes to the surface. And with an audience right now in the tens of thousands, if not hundreds of thousands of people that are watching this play out, willing to crowdsource efforts to put an end to this madness, it really makes you wonder, does she really want to get rid of this generational wealth that was bestowed upon her in the most privileged way possible? Does she really want to do that? Or is she possibly being manipulated by people that would make money aligning their pockets off of this all? Because I know one thing for sure, she ain't going to receive a penny. It's only going to deplete whatever resources she claims to have. So, all the best indeed from Michael Maricini. And we have here the email to Greg Woodnick. I haven't responded to him since I still don't know if he's represented by counsel. So again, it goes on and on. Is this the one? Who's this from? Is this from, let's see the email below from Maricini. I haven't responded to him since I still don't know if he's represented by counsel. I don't really consider Randy Pollack to be representing him with respect to the Arizona case, since she's not licensed in Arizona and hasn't done anything to appear in the case on his behalf. I don't want to communicate directly with Mike. So he does that whole thing like, oh, I don't want to communicate with him after he's already tormented him, shared depositions about him online, and embarrassed him and this and that. I realize Mike isn't actually your client, so I don't know how much control you have with him, but I'm hopeful maybe you can get Mike to change his mind. He's apparently unhappy about something I tweeted yesterday, which I removed after seeing his email. This doesn't seem fair. Jane is being attacked relentlessly on a daily, virtually constant basis by people on Clayton's side. But somehow, if I say or do anything to respond, this is somehow deemed outrageous. It's really frustrating. There are two sides to the story here, and one side seems to be monopolizing the narrative, often with less than total candor. Look, here's the deal. Hire a PR firm. You know what I mean? She doesn't need her lawyer to be speaking publicly about all of this. We're not on anybody's side. We're on the side of truth. I don't understand how he kind of whines like a baby and calls this an unfair fight. Everybody's on the other side. People have come up with the opinions that she committed fraud in multiple different ways. That is why they don't side with her. You know what I mean? Like, what else? It's like, what else do you, like, he gets this, right? Anyways, I want to keep the lines of communication open with you, and I promise to keep things on the same professional level as the conversation yesterday. But I just need to let you know, if Mike won't speak to me, then I have to go back to my previous position that I'm going to ask the court to exclude him from the trial. That's just what the rules require here. So if Mike it's willing to be flexible, then neither can I. It's a typo there. Again, this is not any sort of criticism directed at you. It's just hard when I'm dealing with people who demand that only their side of the story can be told. Because time is so short, I need to know ASAP if Mike is standing on this position. If he is, I will need to file another short MIL seeking to exclude him for non-disclosure. P.S. I sincerely do appreciate you taking the time to talk yesterday, and I'm hopeful that if you need anything or want to talk further, you can just pick up the phone and give me a call. Those direct conversations are so helpful. Emails just don't have the same benefits. Exhibit 4. I believe this is, I don't know who this is from. Some comments back in red. Video testimony. I agree that all witnesses, so this is from Greg Winnick's, this is Greg Winnick's response. Video testimony. I agree that all witnesses, not parties, can appear virtually if they are not local. That seems to work well with bench trials. To be clear, we are not stipulating to the admission of your expert's report, but his testimony can certainly be done via video. My preference is to have everyone testify in person if possible, but I'm just not 100% sure about Dr. Medchill's travel plans. He lived in Phoenix for the last 30 plus years. Oh, so this, okay, so I'm sorry. This is Gingrich's response. He lived in Phoenix for the last 30 plus years and just recently retired and moved to Florida, but he has family here in Arizona and he comes here regularly. Given a choice, I'd like him to appear personally at trial, but if he can't make it, I guess video will be fine, assuming the court allows it. I don't object to you calling anyone by video, but again, I don't know Judge Matta's policy on this stuff, which is why I asked. To the extent it matters, I'll stipulate the video if you want it. Trial time. I will streamline my presentation to fit into our allotted hour. Jane invoked Rule 2 with one of her prior lawyers. Maybe we can maximize our court time if we stipulate to proceeding without Rule 2. I think that also helps keep costs down. I always favor streamlining and simplification, but we need to follow the rules of evidence, so I won't agree to waive Rule 2. That just isn't appropriate in light of the allegations here. There's way too much inappropriate stuff being brought in by your side, so we need the evidentiary rules to help narrow things down. Witnesses. Jane, Mike, and Greg would, time permitting and consistent with the disclosure, will testify that they experience false pregnancy claims. Witnesses, Matt, Mike, and Greg would testify that they experienced false pregnancy claims, altered medical records, suicidal threats of breakups, behavior with their families, and abortion contingent on relationship contracts. Our disclosure statement is reattached for your convenience and includes a summary of their testimony. I'm not sure what happened with your call with Randy, but she likely did not recognize your name, as you are not the first attorney Jane has had in this melee. I have spoken to her, but it was months ago and before your involvement. I have confirmation that Mike fully supports this process. Of course, I can subpoena him, but that won't be necessary. If you call Jane Doe, she will confirm what happened with Mr. Maricini. I sent Greg Gillespie your contact information, so hopefully you're connected. If you feel you need more information per Rule 49J, that is not included in the attachment. Just FYI, based on the comments above, I'm going to file a motion in limine to preclude the testimony of Matt, Mike, and Greg. This is classic prior bad act evidence that is not admissible. In addition, you have never disclosed the substance of any of these people's expected testimony, and it's clear you had that information more than 30 days ago. So the MIL will argue both 404B and untimely disclosure, and frankly, relevance and unproven allegations from an angry ex-boyfriend is literally meaningless in this situation. Experts and doctors. And again, so what we're looking at right now in the center here is Woodnick, and then the reply is Gingras. Experts and doctors. I forwarded your experts draft to our experts. I'm a little confused by your expert report, and while ours forthcoming will certainly not align and was delayed because we are giving Planned Parenthood a second chance at providing the ultrasound, I don't think your doctor's testimony, if accepted by the court, addresses the fundamental problem of your client's behavior in the litigation. Once we receive the final version, we will be making specific content objections permitted by law. I am not going to engage in a debate over the facts, as we can do that in court or with a mediator, as was previously suggested. Parenthetically, I would point out that if your theory about weight gain is quickly refuted by your client's own medical records, per her Banner record, she weighed 121 pounds on June 1st, 2023. Oh boy. Oh boy. Gingras' response. I'm hoping to get your MedChill's final report today, and this will include more information that you don't yet have, such as an affidavit that she gave to MedChill, as well as my cover letter to him, which explains the scope of the testimony I asked for, as well as some specific questions I asked him to consider. You obviously need that additional information to provide context, so this will be sent to you today if possible. Since I don't have your expert reports, I can't really speculate about what they're going to say, but based on the limited info in your third disclosure statement, I'm probably going to bring a motion to exclude your experts based on 702 Daubert and relevance. I'll let you know once I see their reports and have a chance to discuss them with Dr. Medchill. Side note, your third disclosure statement says Dr. Deans is going to testify that HCG tests were never dispositive of pregnancy. Assuming she says this, which is hardly a contested issue, I think it's important to remind you that you are applying exactly the wrong standard here. The only remaining issue is whether Jane should be sanctioned for bringing a claim she knew was false. While you are going to lose that argument for other reasons, to obtain sanctions, you seem to believe that Jane has some obligation to show to a 100% degree of medical certainty that she was pregnant. That is what the JFC crew has been claiming for weeks. That is exactly backwards. Jane simply has to show she has some reason to think she might be pregnant. If she had that basis, she cannot be sanctioned, even if her belief was wrong. At no point is she obligated to establish that pregnancy was confirmed in some dispositive manner, whatever that even means. This is just another reason why I will probably move to exclude Dr. Dean's testimony about HCG not being dispositive. Who cares? That is simply not relevant to any issue in this case. Honestly, I'm guessing Dr. Deans would agree that a positive HCG test does give a woman a reason to believe she probably was pregnant, which would make her a strong witness for Jane's side. Now, of course, that leaves out the whole merit of the case, which is that Jane used this information, HCG, to pull these men into dating contracts and this and that. So it's not whether, they're on literal opposite sides of the world here with what they're arguing. I guess I'll ask her when I see her report. So then we have Woodnick saying motion for judgment on the pleadings and intention to file for sanctions against me personally. If this is how you choose to litigate and to relitigate things that have already been addressed and denied, then a phone call to discuss is not going to impact anything. If it will be more posturing, and I don't think it is helping our clients. File what you must, and we will respond in kind. Gingras said, I don't understand what you mean by this. Things that have already been addressed and denied. I think you must be referring to the fact that Jane's prior counsel asked the court to dismiss the case, and then the judge apparently granted that and then changed her mind. So who knows? Those are two completely different issues. My motion for judgment on the pleadings is going to argue that you cannot get sanctions as a matter of law because you didn't follow the rules. I don't believe that issue was fully raised before, which is why I'm going to raise it now. As for the other issue, that pretty much speaks for itself. Meet and confer. The purpose of a meet and confer is to discuss possible resolutions of issues. If you have a proposed settlement you would like to discuss over the phone, I am happy to coordinate the call, but I am not interested in the scorched earth Conor McGregor stuff. You apologized previously, but reverted to the same behavior online via Twitter and your blog. If you really think the call would be productive, I am happy to coordinate it, but your mind seems very made up, at least from your blogs and whatnot. If you think a call would change your perspective about what you are going to file, I will find time to talk with you this afternoon. Interesting. Did Dave Neal ever share that long email I sent? If you haven't seen it, let me know and I'm happy to share it with you. The point is you misunderstood what I meant about Conor McGregor. Oh, geez, so they're bringing me into it. As I explained to Dave Neal, I have been involved in many cases that were much more contentious than this one. And in many of those cases, opposing counsel ended up losing their licenses. And in more than one case, the lawyers ended up in jail. The Conor McGregor reference simply means I've been dragged into a lot of really nasty fights, never by my choice. And in many of those fights, my adversaries have ended up self-destructing while I'm still here standing. That's what Conor McGregor means to me. It was never a suggestion that I enjoy violent confrontation or that I am out to gratuitously hurt anyone. My point was to say that I am a veteran of many tough battles, and while I would prefer to avoid messy conflicts, I am not afraid of going there if given no other choice. Having said that, I do think we should talk because there are so many moving parts here. Among other things, I just want to get a clear understanding of who is really coming to trial and what they're going to say, bearing in mind I'm still going to seek to exclude pretty much all your witnesses based on lack of timely disclosure. It's hard to have that conversation via email, and yes, I'm more than happy to give you a verbal summary of everything on my side as well. Speaking of which, now that I fully understand the case from Jane's side, I would really find it helpful if you could give me additional details from Clayton's side, especially with regard to this claim that she faked pregnancies with other men. Let me give you an example. In talking to Jane about all of this, I asked her to explain the story of Gillespie. I was curious to know exactly what basis he had for claiming that she faked being pregnant. Jane's response was she had a brief relationship with Gillespie. I think she said they had sex twice and went on like roughly 6 dates over a period of a few weeks. Jane tested positive for pregnancy. Gillespie asked her to terminate the pregnancy medically, which she did about 4 weeks later by taking pills in Gillespie's presence. According to Jane, that is the entire story, aside from the latter litigation, which went nowhere. There was never any ultrasound, why would there be? And there were basically no other medical records involved other than the initial pregnancy test and the later medical abortion. Well, we know this to be false. We've shown the fabricated ultrasounds that she has provided Greg Gillespie and all the information attached to that. Assuming Jane has accurately communicated the above facts, she didn't. I'm guessing that Gillespie's only basis for claiming that she faked the pregnancy is because what? He just doesn't think she actually got pregnant? Pure speculation like that is clearly inadmissible. And if it's not pure speculation, it's not pure speculation. And we have the phone call of Jane Doe calling Greg Gillespie saying, look at right here, one of the twins died. This is where it's at. It's the same ultrasound we've shown has a Fiverr logo. Oh my gosh, will she look stupid if this plays out in court? Not that I think she's got any shame. Pure speculation like that is clearly inadmissible. And if you tried to call Gillespie as a witness and ask him whether he thinks she faked being pregnant with him, I'd object to it due to a lack of foundation and calls for speculation. Well, you're not going to object when you see the ultrasound she sent him. He has a videotape of it. He has audio of it. It happened. After this many years of legal practice, you should know this by now. You can't just call a witness and ask them to guess about whether something happened. The witness must first prove they have personal knowledge of the matter in question. I see no basis to establish that Gillespie has personal knowledge of Jane not being pregnant. Same thing with Maricini. His lawyer also told me he is not testifying at trial. So this was, previously. Same thing with Matt. Moving forward, I know Redacted wants this to be over, and candidly Clayton does too, but that requires her acknowledging how dishonest her behavior has been. So again, this part is from Woodnick. I only speak for Clayton, but he does not seem interested in more litigation, both because Jane is probably judgment proof and because he has wanted the same thing since day one. He does not believe the pregnancy as they did not have sex, and for all the myriad reasons you already know, including the nearly identical stories from 3 other men. All Clayton has ever wanted is an acknowledgement by Jane. She has a pattern of lying about pregnancies to force relationships with the guys who have rejected her. Even accepting, which we don't, that she was pregnant without intercourse, and your expert's conclusion that she was pregnant with Clayton's twin children without any DNA testing and with a fabricated ultrasound, it does not change what has happened since her alleged miscarriage or her conduct predating this litigation. This ends either with trial in June or with Jane coming clean. This is her out. Gingrich replies, I'm happy to discuss settlement, but I also need to be honest. When Jane prevails in this case, she's going to sue Clayton and many other people for defamation and other torts. We can certainly avoid that if you want, but it's going to involve someone writing a very large check to Jane. If you offered $1 million right now, I'd advise her to reject that offer. So as it turns out, the settlement that he wants is for Clayton to pay her, which again shows, money being demanded here. So yeah, happy to talk about settlement if you want, but I don't think that is likely to happen. Progress, assuming she wants to continue down this litigation path, as we agreeing that witnessing is by video and no more Rule 2, can we still preserve issues with regards to the docs? Anyway, earlier we have an email saying, Greg, we need to talk about witnesses. I'm asking because obviously it's not possible for you to call 9 people in the 60 minutes your side has. I'm also asking because when I see newly disclosed witnesses, there isn't any disclosure about what the person is going to say. I like to just pick up the phone and ask the witnesses. So I just tried calling the contact person you have listed for Mike Maricini. Randy really surprised me. She said she had never heard of this case, never heard of me, never heard of you, and as far as she was aware, Mr. Maricini wasn't coming to testify as a trial witness. I also tried calling the contact person you listed for redacted, got voicemail. Hopefully she will call me back. I was going to call Greg Gillespie, but it's not clear to me whether he's represented by counsel. If I don't get any responses, I'm considering whether we should just depose these folks, but I'd like to avoid the extra costs if possible. Anyway, the easiest, just depose them. Depose these guys. Anyways, the easiest thing to do here is for us to have a conversation about who you are actually planning to call at trial. Right now, my witnesses are Jane Doe, Clayton, Jane Doe's mom, and Dr. Medchill. I'm planning to send you an updated disclosure statement next week, which includes summaries of all witnesses expected testimony, plus all my trial exhibits. And if Dr. Medchill's report is ready by then, I will include it as well. On that note, I'd also like your input on whether you're okay with having out-of-state folks appear by Zoom. Dr. Medchill lives in Florida, so this was the previous email. I appreciate getting the same info from you, which people you actually plan to call and what they are going to say. Obviously, it should come as no surprise that we are not expecting you to wait until the last minute, May 10th, to finally disclose the substance of what each witness is going to say. If that happens, I'll move to exclude all that info as untimely per Rule 49B, since you didn't disclose it within 30 days of learning the information. I'm also considering a Rule 404B motion in limine as to Gillespie, Maricini, and Matt, but I can't really do that without knowing what you plan to have them talk about. Look, despite all the animosity, there is still a lot of stuff we can do to get this thing ready for resolution. All I'm asking is for you guys to follow the rules. I'm trying to do that, and it's not unreasonable for me to ask the same from you. How funny, how rich. He says, despite all the animosity. This is the Conor McGregor of litigation right there. Well, he brings me up in this email to Woodnick. I actually have never sent that email to Woodnick. I just sent it to my own counsel because we're not all on the same side here. But I think it's time, and let me guys know what you think. I think it's time I share publicly what was said to me in that email. Let me know what you guys think. Maybe we'll have that video coming up sooner than later. All right, folks. I'm going to be a little late on Patreon today because I have an interview to go do. So Patreon will be around 1 p.m. Central Standard Time. I'll see you guys then. Bye, everybody.